Hi, this is Bishop Andrew Randall with part 2 of Show Me the Money for your legal tip for today. In the first episode, we talked about how it is that a church and a pastor were in dispute surrounding the terms of his contract for his retirement separation agreement or compensation. And they are currently in court trying to decide whether or not they should pursue a path of arbitration, mediation, or adjudication, which means moving forward in court. Let's talk briefly about the differences between them. Mediation is when parties get together and you have someone who literally allows them to come into the room in an informal way. Each of them is allowed to share their concerns and their issues, and the mediator's job is to try to allow those parties to come to some sense of agreement. It is essentially a negotiation. It's informal, so no parties are giving any terms under oath, and there's not an evidentiary process like discovery as would take place in an arbitration or even in a traditional litigation sense. And so even when those parties come together in a mediation, whatever decision is arrived at, it's by consent of the parties, and neither party is bound toward that. Mediation is generally less expensive and done in advance of litigation to prevent you from coming into court. Arbitration is different. It's a formal process, and that's not a negotiation. There's an adjudication. The arbitrator, the person that's overseeing those proceedings, handles a much more formal role. It's generally more costly, and it can take longer. And the decision of the arbitrator is done based on the law and the facts, not on the feelings of the parties that are participating in. And then lastly, whatever decision that the arbiter makes, that the parties are bound by that decision. Now, each of those, whether it's arbitration or mediation, are generally private. However, in the instance of arbitration, if there's an award that's given, it will be made public. Much in the same way that litigation takes place in a trial, those things then also become public record. So carefully consider arbitration, mediation, or litigation when drafting contracts or considering how disputes would be solved between parties.